A lot of Gulf War and post 9/11 veterans have been hearing about the PACT Act, and by 2026, more of them are realizing that the law may apply to conditions they were previously denied for or conditions they never filed for because they assumed service connection was impossible. So veterans are filing, veterans are refiling, and a lot of them are walking in with the same assumption. If my condition is now presumptive, the VA should just approve me. Not necessarily. Veterans are still getting denied, still getting deferred, still getting underrated, not because the law did not change, not because they do not have real conditions, not because they did not serve, but because presumptive service connection does not work the way most veterans think it does. In this video, I am going to show you what the PACT Act actually changed, who it may help, and just as important, what it does not fix. So if you are a Gulf War or post 9/11 veteran, you know exactly what your record still needs to show before you file or refile. This is episode 2 of the Over 40 Veteran Gap Strategy. In episode 1, we talked about proving service connection years after the fact and why a long gap between service and your current condition does not automatically kill your claim. But the gap does not explain itself. The record has to tell the story. This episode builds directly on that because the PACT Act changed something real for Gulf War and post 9/11 veterans. And if you do not understand what changed and what did not, you may walk into a claim with false confidence and come out the other side with a denial you did not see coming. So let's clear the battlefield before you step into it. Section 1: What the PACT Act changed and why veterans are still acting on it now. Let's start here, because if the title brought you to this video, you deserve to understand what the actual change was before we go any further. The PACT Act, signed into law in 2022, was one of the most significant expansions of VA benefits for toxic exposure veterans in decades. For Gulf War veterans, it clarified and expanded the conditions the VA may presume are related to Gulf War service, things like undiagnosed illnesses and certain chronic conditions associated with that service. For post 9/11 veterans, veterans who deployed to places like Iraq and Afghanistan, it addressed burn pit exposure, airborne hazards, and other toxic exposures that were not clearly covered under prior rules. This is not breaking news. The law was signed in 2022, but here's the reality. A lot of veterans are still hearing about these rules for the first time. A lot of veterans who were previously denied are now realizing there may be a path back in. And a lot of older veterans, veterans who pushed through symptoms for years and assumed it was too late, are now asking whether this law applies to them. That is why we are talking about this now. And I want to be clear, I am not here to minimize what the law changed. For veterans with the right conditions and the right service history, this is significant. But here is what I am here to tell you. Presumptive service connection may remove or reduce one major hurdle in the claim, but the veteran may still need the right diagnosis, qualifying service facts, and evidence that the condition exists at a compensable level. The rule may open the door, the record still has to walk through it. Section 2: What presumptive service connection actually means. To understand why this matters, you need to understand how a standard VA disability claim works. In most claims, the VA is looking for three things. One, a current diagnosis, something that exists and is documented now. Two, an in-service event, injury, illness, or exposure, something that happened during your service. Three, a link between the two, a nexus, a clear connection between what happened then and what you are dealing with now. That third piece, the nexus, is often the hardest one to establish, especially when time has passed, especially when records are thin, especially when the exposure was environmental and no one wrote it down clearly in your service treatment records. That is where a presumptive rule can help. Under a presumptive rule, the VA may presume the connection. You may not have to prove the exact medical link between your service and your condition. the same way you would for a direct service connection claim. That is significant. For veterans with long gaps and thin paper trails, that can be a real advantage. But here is what veterans miss: presumptive does not mean automatic. That is the part veterans miss. The presumption may help with the connection, it does not build the whole file for you. Section 3, what the record still needs to show. So, if a presumptive rule may remove or reduce the nexus hurdle, what remains? Three things still matter every time. First, a diagnosis. You still need a current documented diagnosis of the condition you are claiming. Not a symptom, not a suspicion, not, I have been dealing with this for years. A diagnosis in your records from a qualified provider, documented clearly. If the condition is not documented, the VA has nothing to rate. Second, qualifying service or qualifying exposure. Presumptive conditions under the PACT Act are not available to every veteran by default. There are criteria, there are qualifying service periods, there are qualifying locations, there are qualifying exposure situations. The VA is going to look at your service record to confirm that you meet the criteria for the presumptive rule to apply. If your service facts are not clearly documented, if the record does not show the qualifying service or exposure, that is still a gap that needs to be addressed. Third, evidence that the condition exists at a compensable level. Service connection is not the finish line. Rating is. Even if the VA grants service connection under a presumptive rule, the rating they assign depends on the evidence in the record: severity, frequency, functional impact, what the condition actually prevents you from doing in daily life. A 0% rating is still a service connection decision, but it may mean no compensation, and it may not reflect what you are actually dealing with. A diagnosis matters. Qualifying service facts matter. Clear evidence of severity and functional impact still matters. That is where veterans lose ground, not because the law was not on their side, but because the record did not show the full picture. Section 4, the over 40 veteran gap. Reality. Let me make this real. Think about a veteran who deployed to the Gulf, came home, pushed through symptoms for years: fatigue, joint pain, cognitive issues, GI problems, never connected the dots, told himself it was not bad enough, told himself too much time had passed. Maybe he filed once and got denied. Maybe he never filed at all. Now he hears about the PACT Act. He learns that conditions tied to Gulf War service may now fall under a presumptive rule. He thinks, this is it, this is my shot. He files, and the VA comes back with a denial or a deferral, not because he does not qualify, not because the law does not apply, but because the record is thin. No current diagnosis that clearly matches a qualifying condition, or service facts that are not clearly tied to a qualifying exposure, or a record that shows a condition exists but does not explain severity or functional impact. The gap did not kill the claim, but the gap did not explain itself either. This is the pattern I see with older veterans: real conditions, real service, real symptoms, but a paper trail that does not tell the full story yet. The PACT Act may have reduced the nexus hurdle. It did not write the rest of the record for you. Section 5, what to review before you file or refile. So, what does this mean practically? If you are a Gulf War or post 9/11 veteran who believes a presumptive rule may apply to your situation, here is how to think about your record before you move. Start with the diagnosis. Does the record clearly show the condition exists? Is it documented by a provider? Is it current? If not, that is the first gap to address: not the form, not the filing date, not the law, the diagnosis. Review your service history. Presumptive rules have criteria: service periods, qualifying locations, qualifying exposures. Before you assume the rule applies to you, make sure your service facts can support that. That may mean pulling your DD-214, your deployment records, or other documentation that confirms the qualifying service or exposure. Look at the evidence for severity. Service connection is not the only question. Rating is also a question. Make sure the record reflects not just that the condition exists, but how it affects your daily function: work, sleep, physical capacity, daily responsibilities, the things the condition stops you from doing. And if you have already been denied and are not sure why, slow down before you refile. Read the decision letter carefully. Look at the reasons for decision. Look at what the VA said was missing or insufficient. Look at what they conceded and what they denied. That letter may be telling you exactly where the record is still thin. This is not about fear. This is about preparation. Clarity before action. 48-hour challenge. Here is your challenge for the next 48 hours. Write down three things. One, do I have a current documented diagnosis for the condition I am considering filing? Is it clearly in the record? Two, does my service record clearly show the qualifying service period, location, or exposure the presumptive rule requires? Three, does my medical evidence show the severity and functional impact of the condition, not just that it exists? If you can answer yes clearly to all three, your record may be in a stronger position. If one of those boxes is empty or unclear, that is the gap to address before you file, not after. This is not legal advice. This is not me telling you what to file or when. This is helping you get organized so you can move forward with more clarity. Recap. Let me bring this back. The PACT Act changed something real for Gulf War and post 9/11 veterans. Presumptive service connection may remove or reduce one major hurdle in the claim, but it does not remove all of them. A diagnosis still matters. Qualifying service facts still matter. Clear evidence of severity and functional impact still matters. Presumptive does not mean automatic. The rule may open the door, the record still has to walk through it. The gap does not always kill the claim, but the gap does not explain itself. Understand what changed and what did not before you move. In the next episode of the Over 40 Veteran Gap Strategy, we are going to talk about continuous treatment, what it is, why the VA pays attention to it, and how veterans with a long medical gap can begin to address that before they file. Because a presumptive rule may help reduce the nexus hurdle, but if your records show a 10-year gap in treatment, that gap still tells a story, and you want to be the one who explains it. That is next. If you already have a VA letter and you are not sure what it is telling you, whether it is a denial, a deferral, a request for more evidence, or just confusing VA language you do not fully understand, I want to point you to one place before you take your next step. Use the free VA Letter Translator at veteranclaimsmadeeasy.com. Paste your letter in. Get a plain English breakdown of what the VA appears to be saying, what may matter next, and what to review before you move. It is not legal advice. It is not a guarantee of anything. It is a calmer starting point, so you are not guessing at what the VA meant before you decide what to do next. Start there. Get clarity first. The link is in the description. This is educational and organizational support only. It is not legal advice, medical advice, accredited representation, claims filing, or a guarantee of VA benefits. My goal is never to mislead, only to empower you with accurate, honest, and actionable information. Semper Fidelis and God bless.